Go!
Breaking news. Welcome to today's headlines. Nnamdi Kanu's basic right claim against the DSS is dismissed by the court. Nnamdi Kanu's basic right claim against the DSS is dismissed by the court. To my dear listeners, from wherever you're listening from, please stay tuned as I read today's news. On Friday, a federal high court in Abuja dismissed a basic right enforcement suit brought by Nnamdi Kanu, the leader of the outlawed indigenous people of Biafra, IPOB, against the Department of State Services, DSS. The claim was rejected by Justice Taiwo because it lacked merit and substance. According to the Nigerian news agency NAN, Kanu sued the Director General of the DSS and the office as first and second respondent in a basic right enforcement suit filed FHC ABJ CS 1585-2021 through his lawyer Maxwell Okpara. In the complaint dated and filed December 13, 2021, he also included the Attorney General of the Federation, AGF, as a third respondent. Kanu said that while in DSS custody, his health was failing, and that the medical staff given to him by the DSS were incompetent, among other things. The DSS, however, disagreed with Okpara through its lawyer, Idowu Awo. He claimed Kanu's counsel had failed to demonstrate how the physicians treating his client were performing quack work. He went on to say that just declaring that the medical professionals his office sent to Kanu were quacks did not constitute a conflict of interest, and that Okpara had not shown any proof to substantiate that the listed medical practitioners were quacks. He pleaded with the judge to dismiss the application. Simon Enoch, the AGF's counsels, backed up Awo's claim, urging the court to deny Okpara's application. Justice Taiwo, who delivered the ruling, stated that Kanu had not produced adequate evidence that the security organization had violated his fundamental right, since there is no proof of torture before the court. While the applicant, Kanu, has the constitutional right to practice his religion in detention, the judge agreed with the respondent's argument that a suspect in custody cannot be permitted to practice his religion in a way that disturbs the quiet of other suspects in custody. On the claim that the IPOB leader was receiving substandard treatment from DSS doctors, He had referred to as quacks, Taiwo said that the applicant failed to lead evidence by calling a medical practitioner to convince the court that the treatment given to Kanu is inadequate based on the medical report. As a result, the judge rejected the case because it lacked merit and substance. In a talk with Nan immediately after the judgment, Okpara said the judgment will be appealed to the Court of Appeal. He said that the judge denied his plea to have the DG of the DSS and cannot give oral testimony in court to determine the fact of the case. On March 16, Justice Taiwo denied Okpara's plea, seeking the court to call the DSS DG and Kanu to give testimony. According to Nan, fundamental rights cases are exceptional cases. Sui generis, according to Taiwo, and the manner of beginning is affidavit evidence as provided by Order 2, Rule 2 of the Fundamental Human Rights Enforcement Procedure Rules 2009. Though there are other ways to start a lawsuit, including in basic rights situations, Justice Taiwo noted, Kanu applicant opted to start his under the Fundamental Right Enforcement Procedure Rules, which mandate affidavit evidence. After carefully reading all of the applicant and respondent affidavits before him, he concluded that there were no irreconcilable inconsistencies in the affidavit. As a result, the judge denied Kanu'S request and he was discharged as a result. To my dear listeners, now we've come to the end of our today's news. Please do drop by at the comment section and let us know what your view is all about. Thank you for listening.